In this video, we'll talk about whether somebody who is in the process of getting divorced overseas can remarry in the United States before that divorce is final. Before we dive into this topic, if you're here for the first time, make sure to subscribe to our channel, click that bell to be notified, and if you have Instagram, follow us on Instagram as well as TikTok for other videos, opportunities, and to engage with us there as well. So this is actually a video that I'm doing as a response to a question from one of our subscribers who described a situation where they are currently in the Philippines and it takes really many years to get divorced over there. Papers are filed, everything is there, but it's not final. And the client was saying that, listen, this is the Philippines, it's far away, it's not the US, nobody's gonna know about it. I just wanna get married with my current fiance so I can go ahead and file for my green card and get over with my life. The issue with that is if you file for a marriage petition, file the adjustment of status while you're still married, even if it's in another country, the consequences are devastating because by the time you get to the adjustment of status interview, if they find out at that point, your marriage will be null and void as well as your case, and you may be subject to removal proceedings because by the time you may be already overstayed or your status may be already expired. But the biggest consequences of this are that you may be charged with fraud, misrepresentation, and even if they don't find out during the green card process, don't forget that that's why they have all these protection. That's why you have a conditional green card for 2 years, whereby they can check and investigate further. And even if they don't catch it during the 2 years after the removal of conditions, things may come up during the citizenship process 3 or 5 years later down the road. So, and if that happens, imagine how devastating it is where you may lose your green card that may be rescinded. We never recommend anyone, and this is actually one of the first questions that we ask in our questionnaire, we want to see your divorce decree from a prior marriage, because that is why the US government is so strict about it. That is why a divorce decree is one of the key elements, part of the evidence of an adjustment of status case. You cannot file an adjustment of status until you're free and clear to marry another person again. So divorce in the home country is essential. No matter where you are in the world, you have to file a clear divorce before you can actually marry another person here. Now, the significance actually of this is one of the things that you need to prove in an adjustment of status case is that you're actually eligible. And people know that they have to make sure that they have all the criminal stuff. If they have a criminal, they have to get all their certified records of criminal records. They have to disclose that. For somehow, many applicants kind of look at a divorce decree as something that is minimal, and they don't realize that it's actually one of the most important parts of the evidence of an adjustment of status case, where you have to show to the government that you're free and clear to get married to a new person in the United States. And it doesn't matter that it happened in a foreign country. It doesn't matter that that marriage was was just a religious marriage or whatever. As long as it's recorded in the country, you have to have a real and certified divorce before you can marry another person in the US and file their adjustment of status. So make sure you never do that. Always get a certified divorce before you are about to file an adjustment of status case. So this is just an answer to one of our followers, one of our subscribers' question. We do videos sometimes based on your questions. If you have any questions that you want us to make a video, post them below and we'll try to make it in our next video. Thanks for watching, and we'll see you in our next video.